Welcome to HR Voices, a podcast for independent HR and people professionals and the businesses they support. HR Voices is brought to you by the expert team at HR Independence Limited. We hope you enjoy.
Hello, everyone, and welcome to another episode of HR Voices podcast. I am your host, Mary Asante, and with me here today, I've got the fantastic Amanda Trewhella. Hi, Amanda.
Hi, Mary. How are you doing?
I'm all right, thanks. How are you?
Yeah, very good. Thank you.
Great. So, Amanda, I'll let Amanda introduce herself, but we work very closely with Amanda because Freeths is our legal partner, and Amanda supports us together with her team with our Ask HRI help desk. So, thank you so much for the incredible work that you do with our members through the help desk, Amanda. So, for the benefits of those who may not know who you are, I know a lot of our audience will know who you are because we host webinars together and we do loads of work together with yourselves. But for the benefits of people who may not know who you are, can you give a brief introduction to yourself?
Of course, yes. Hi, everybody. I'm Amanda Trewhella. I'm a director and employment lawyer at Freeths. Freeths are a sort of top 50 full-service national law firm. We've got offices all across the country, 13 different offices. So I'm in the employment team here in London, and as Mary said, work very closely with HRI. So I'm sure lots of you will know me already.
Excellent. Thank you for that. And today we have the pleasure of discussing the Employment Rights Act 2025. I know that there was a lot of panic when the bill was going through Parliament with all the discussions, the uncertainty around it, etc. But eventually, towards the tail end of last year, it received royal assent and became an act. So, yes, we're here today to talk about the Employment Rights Act, some of the changes that is going to, or the impact is going to have in the workplace and especially the employer-employee relationship. So I'll hand over to Amanda to tell us more, just a really high-level overview of the Act and what it really means for the workplace.
Yeah, absolutely. I don't know if it's possible to give just the high overview of the 300 odd pages of the Act.
Absolutely. That's why I hesitated when I said high level. How do you summarize a 300-page document to a one-page executive summary, right?
Yeah, exactly. So it's going to be so many changes to employment law. Obviously, the bill's taken a long time to get through Parliament, so we already know the headlines, we're already aware. As you say, we have the Act now since it got royal assent at the end of last year, but it's not quite the end of the story yet. There's still lots of consultations ongoing, and some of the regulations are subject to other regulations coming in first to iron out the details of the new regulations. So we've got the main headings. I don't know if you want to sort of walk through the different changes in particular.
I think that would be helpful. Talk through the different changes. Yes.
I think the one, stop me if I'm wrong, but I think the one that people are most concerned about is in relation to unfair dismissal.
Yes.
And of course, as we know at the moment, people have to work for 2 years before they get unfair dismissal rights. And from January, that's going to go down, January 2027, down to just 6 months. So that's a really big change, I think, as to how we're all used to dealing with issues. And of course, if an employee was underperforming in the early months or year, say, of their employment, it's always been fairly easy to deal with. I think is going to have to be quite a big mind shift change to now having only a 6-month period to deal with any issues, and if it's not working out, to dismiss them before they do get those additional rights. And here,
go on.
Yeah, and so it's just really a shift as well, not just for HR professionals, but for managers in particular, in relation to dealing with those issues as and when they arise much earlier than they're used to doing at the moment.
Yes, and I think it directly to the lots of questions which comes up within the HR community is, oh, does this then mean that employees are going to change how long probationary periods are for? And I don't know whether you get those questions as well, Amanda, from your clients around, okay, what does this really mean? If after 6 months someone can get the rights to effectively contest some of the decisions that employees make, then does that really mean that we shorten people's probationary period? Or sometimes people are thinking we increase it to 6 months, etc. But what is your take on that?
Yeah, it's something that is coming up a lot. And I think my feeling is a slightly shorter than 6 months probationary period makes more sense to me. Obviously depends upon the role, but whether you start with a 3-month period, but with a right to extend that by a further 2 or 3 months perhaps. And I think that will really encourage people, managers in particular, to be really assessing at that midpoint of 3 months before they get to the 6-month service to be able to claim unfair dismissal. I think the risk of having a 6-month probationary period is we know what tends to happen is people wait until the end of that 6 months, and will they give themselves enough time to deal with any issues, give somebody notice and dismiss them before they get the 6 months accrued service. So my feeling is 3 months with an option to extend that for a further period is a safer way of doing things than having 6 months. And you certainly wouldn't want a longer period than 6 months as your probationary period at all.
And I think the reality is, for most roles that I've been involved in over the years, probationary period is 3 months for most roles. And it tends to be more for senior roles that you're likely to come across a 6-month probation or something longer than that. So in practice, it shouldn't really change much in terms of probationary period for most existing roles. But I think you are absolutely right. The mindset shift will be around not making your probationary reviews or your probationary period a checklist thing, and being, as a manager, on top of your game to make sure that you are regularly reviewing the employees, addressing any issues that come out very, very early on, and not waiting till the very end before you start to address it. Because the reality is, I think, where potentially claims might start to go up is that, from an employee's perspective, you've not told them anything is wrong as such. And then suddenly you rush to say everything is wrong and you need to leave, and you need to leave now. And that is where a lot of the time, I think, come as a shock to people, because hang on a minute, no one ever told me that I wasn't performing. No one told me there was an issue. Then suddenly there's an issue. No, actually, I think there's more to this than that, because you're trying to say, I'm not performing. And actually, I think you're discriminating against me for whatever reason, right?
Absolutely. Yeah, exactly. I mean, when it gets to dismissal time, it shouldn't come as a surprise to the employee. If they are being dismissed, it should be because major's gone wrong, conduct issue, and it was summary dismissal. That's a bit different. But if we're talking about performance issues, they should be aware from right at the beginning if there are problems, so that if it does get to the point of dismissal later on, that they know the real reason, the genuine reason. And like you say, because if you don't give that reason, they're going to start looking for other potential reasons that it could have been, like discrimination, for example. And then, of course, that leads to an increase in claims.
Excellent. So we've touched on unfair dismissal being shortened from 2 years to 6 months from January 2027. Is there anything else that we need to be looking out for?
Yeah, absolutely. I mean, in terms of timeline, there's a couple of things very close by on the horizon in April. Of course, you've got the changes to statutory sick pay, whereas at the moment you have your 3 waiting days. Those will disappear so that everyone will be entitled from day one. So a fairly minor change even, but something to change in terms of your policies and just to be aware of. And also at the same time, parental leave and paternity leave will become day one rights as well. So again, points there just to make sure that your policies are up to date before that comes in this April 2026.
And yeah, so the day one rights changes in practice, I think, especially for a lot of small to medium sized organizations, will be quite challenges. Like you're saying, it's just a subtle change, isn't it? From an entitlement from day 3 or 4 for sickness, absence, and probably previously for a much longer period for paternity, maternity, etc. And suddenly it becoming a day one right. And I can almost foresee sort of the discomfort it creates when, and we've had that in the past because a lot of the time people don't plan when they get ill.
Mm.
And when someone is starting a job today and they're unwell and not coming in, I know how sometimes managers go, oh, is this going to work out? Is their day one and already
Yeah.
they are not coming in? And so this, on one hand, is really good because the employee who is probably potentially unwell and maybe quite unwell. It's not panicking about, am I letting my employer down? I know lots of employees would worry about, I'm supposed to start my job today and I can't go in. And I know a lot of people will worry about that.
Of course, yeah.
And actually, I think very few will think, oh, day one, I don't feel like going in, so I'm not going in for whatever reason. Nonetheless, from a manager's point of view, from an employer's point of view, there ought to be a mindset shift, isn't there? Where, yeah.
Yeah, exactly. And of course, the only real change, I mean, if people are sick, they've always been able to take sick leave. It's just that they'll now have sick pay for those first few days, as well as from the 4th onwards. And of course, for some small employers in particular, and for with people with low paid workers, generally, it's going to cause more of an issue, maybe. And I have heard some companies are worried that employees might be working for different people and then go off sick on one and get paid and then actually be somewhere else, and that's a whole other story and difficult to know without sending a detective as to whether that's happening. But in reality, SSP, we know it's very, very low. I can't think of how much it is now, £100 a week.
That depends on the organizational culture and their policy, isn't it? Because if it's an employer who has got a generous sickness pay policy, then pretty much, and if they choose to extend it to day one employees as well, then someone can potentially be on more than SSP, which is statutory sick pay. They would be earning what they would have otherwise earned if they actually went into work. And I think sometimes that's where the nuance is, isn't it? From HR point of view, do you go, right, okay, within someone's probationary period, or they get is the SSP or statutory sick pay, and beyond probationary period, then they get the company's contractual pay if you're worried about that. But
Exactly.
yeah.
Yeah, exactly. And I think that's something there was maybe some confusion and thinking, oh, if we have company sick pay, does that also have to be from day one?
From day one.
Company sick pay hasn't changed. That's completely down to the employer and the employee. So as you say, the company's got a choice to make now. Do they want to make company sick pay also from day one? Do they want to have some waiting days? Or I say quite commonly during probation, maybe company sick pay isn't payable during that point while you're just getting to know the employee. And that's probably advisable in most cases.
Yeah. And you touched on a point earlier about people worrying about if, and mostly it would be people on zero contracts and stuff who would work for multiple employees, right?
Yeah.
Most employed people have one full-time job that they do and may have an extra job, but that would be on their off days or out of work hours, etc. So wouldn't necessarily interfere with their day job and the commitment to that. But where people are on either contract, 0 hours, etc., and that's where the flexibility normally comes in for them to be able to do multiple jobs. And I think that's where the concern that you just outlined about are they telling me they are sick? But actually, I know that we're working full time for that one. And that is quite a difficult thing because you need to work on trust,
Of
right?
course.
You don't want to spend all your time as an employer worrying about are they working for someone else or not? Because they
Mm,
are allowed to work for other people. Just how do you balance without getting detectives out there?
exactly.
But are they really sick or are they not sick? And
Yeah,
the rest of it. But
it's very difficult. Yeah.
certainly something that you don't want to be worrying about on the first day of someone starting a job with you.
Mm, definitely. Yeah. Yeah. A tricky one. And like you say, you hope you can trust your employees. And if you can't, maybe you need different ones, really.
Yeah. And with paternity pay, I know lots of people are now compared to when the statutory paternity pay was introduced some time ago and encouragement for shared parental leave and all those sort of things. But I still know that quite significantly when it comes to paternity leave, there's still a little bit of apprehension about it, people taking leave, isn't there? So is
Mm.
the day one right in reality going to be a good thing for people who may have that worry already or not?
Mm. Yeah, I mean, with the paternity day one rights and parental leave as well, it doesn't affect paternity pay. So they still need to have been there for a period of time to get paternity pay. So it's just the leave. So I think it can only be a good thing, obviously, particularly for employees. And of course, we're only talking about 2 weeks of paternity leave. Again, if you've got a company policy that provides enhanced leave, that's completely separate to this and doesn't have to be changed necessarily unless you want to. So yeah, we're talking about the 2 weeks of leave when a baby arrives. I don't think anybody would say that that's unfair. It was probably more an unfair situation where people would start work and have no leave at all. So I think it's probably a good thing all around that one.
Yeah, and I think overall, a lot of these family leave and family oriented policies long term wise is to the advantage of the employer because employees really remember and they
Mm,
do appreciate that, okay, my baby was due, let's say, in 2 weeks' time or so, but for whatever reason, it decided to come today. So,
mm,
yes, I need leave, and my employer was very supportive,
yeah.
although I was just starting with them, they were very supportive, etc., and gave me that time off and the peace of mind to be with my family.
Mm,
And then, so when you come, you build goodwill with that.
absolutely.
And
Yeah.
it's not just, okay, yes, statutory leave, have that. But I think the reality of how you treat people
Mm,
during these times actually go a long way to build some goodwill in the employer employee relationship. I think
mm,
we finding that more and more goodwill is being eroded
mm.
because yeah, and yeah,
Yeah, absolutely. Yeah, these types of leave, and especially if companies give extra flexibility as well, I think goes a really long way in terms of employee relations.
yeah, absolutely. So again, we've covered the day one rights with paternity and sick statutory sick pay. What else do we need to look out for?
Mhm. So just also happening in April, it's not something you need to change as such, but just to be aware of is in relation to collective consultation in a redundancy situation. So of course, this is where there's currently, as the law stands, 20 or more people that potentially would be made redundant and you have to go through a collective consultation process with reps. The only thing that's changing is in relation to the collective award that the employees can claim if you don't
Mm.
do what you're supposed to do with the collective consultation. And at the moment, it's 90 days pay per employee, and it's doubling to 180 days pay. So that's really something, of course, in terms of the procedure, it's something we should have been doing anyway. But if you don't, and if we're talking about large numbers of employees, it could get really, really expensive. So here's just making sure that you have your processes in place and companies are taking advice to make sure that they're doing everything properly as well.
That is going to be a nightmare because you
Mm,
and I know that once you are involved in collective redundancy situations, there's so many things that can potentially go wrong.
mm,
and quite easy for employees to link it to the process,
Mm.
because anything from, hang on a minute, have you been planning this all along and you're only just telling us about it? Which
Yeah.
is always a fine balance with management, because when you talking about restructuring, redundancies, etc., sometimes it looks like you're going to have to do something, and then something happens, either you get massive contracts or change in the market or something,
Yeah.
then suddenly you feel, okay, we are okay, we don't have to do this. So you don't go through any consultation or anything like that. And something may change suddenly again, which really means that you are back on the table and you're having to do some of these things. And sometimes it's very difficult to convince your workforce and their representatives that that was genuinely what was happening, isn't it?
Absolutely. Yeah, it can be really difficult balance. And of course, you're supposed to, or you should consult with employees when it's at a formative stage and decisions haven't been made in terms of final decisions for a new structure. But we know that, the reality is, as you say, things can be fluid and changing. Maybe we'll get this contract, maybe we won't. And it's a balance between consulting with the employees at a formative stage, and so that it is a genuine, meaningful consultation. But also, of course, you don't want to consult too early when everything might be okay, and you don't want to unsettle everybody. So it is, of course, quite difficult
No.
deciding.
People become unsettled. You may lose your very good employees
Yeah.
because they will panic, start looking for jobs and all that, which is a real concern for employers. And of course, it's not the reason why not to consult, but I know it's sometimes the reason why employers want to be certain that they are going ahead with it, because they don't want to unsettle the workforce. And that is always a challenge, isn't it?
It is very challenging.
But 180 days, almost certainly for most employers, is a good enough reason to make sure that you get the process right, you get the right level of advice, and you engage in meaningful consultations right from the beginning, and also ensure that you treat the people who are affected well.
Definitely.
Yeah. Okay. So then the next one then, in addition to that, there are also expected changes around the 0-hour contracts and casual contracts, aren't there?
Yes, exactly. That's not until 2027. I don't think we've got a more fixed date than that. So here, yes, we're talking about 0 hours workers or low hours workers where they're not guaranteed many hours. So particularly hospitality industry, that type of thing. Big changes for that industry when it does actually come in. At the moment, of course, you can just agree a 0 hours contract, but in future, you'll still be able to have 0 hours contracts. But once they've worked for you for a period of time, then you're going to have to offer the employee a permanent hours contract based on the average hours that they've worked. And at the moment, this is still subject to consultation and final regulation. So we don't know what the period of time is going to be that they've got to work with you first, and how long the average is going to be taken over. In an ideal world for employers, it would be a year average, because of course lots of work is seasonal, but we don't yet know how that's going to look in terms of those time periods. And yeah, it's going to make it very difficult for companies that are used to relying on 0 hours workers, definitely. And whereas in the consultation, they talked about, should it be a right for the employee to ask for a permanent contract or permanent hours contract? And it was decided, no, it should be the employer that's obliged to offer it. And even when you've offered it once, the employee can either accept it or carry on as a 0 hours worker. But if they don't accept the offer after a period of time, the employer's then got to offer them again a permanent hours contract. So in terms of admin, it's going to be an absolute nightmare. And of course, the date that you're going to have to offer to each individual employee is going to depend on when they started. So yeah, someone's going to need to create some sort of clever software, I think, to keep on top of all of that.
And that's exactly what I was thinking. A really good gap in the market for software developers and platforms to really come up with something that automatically highlights. And I think the reality is that maybe some of the existing HR software and stuff like that could potentially, because a lot of them you will be able to use to highlight people's probationary period coming to an end and stuff like that. So hopefully
Yeah,
tweaks in that to accommodate for contracts coming up based on how long they've been working for you or what the legislation says would help with the admin burden that comes with it
absolutely.
and
Yeah,
not become too onerous on teams
mm,
to do these. So it's a watch this space, as you said, because there's
exactly.
still a lot coming up on that.
Mm.
So yeah. Anything else?
Yeah, so the next big one I think is about harassment. And this one, we're moving a bit nearer in time, is in October this year, October 2026. So we know at the moment all companies have the duty to prevent sexual harassment, and it's a duty to take reasonable steps to prevent harassment. From October, that's going to change and get a bit tighter, and it's going to become a duty to take all reasonable steps to prevent sexual harassment. That's coming in October. Now, the government is going to give some guidance as to what all reasonable steps means, which is really helpful. Save that, they're not going to publish the guidance until 2027. So the duty is going to come in before the guidance, which is not ideal as it is at the moment. So we'll have to wait and see what that means. But you would hope most companies now are aware of this duty and have trained everybody, have policies in place, have done a risk assessment, etc. Then the other side that's changing also in October is in relation to third-party harassment. So at the moment, the duty to prevent sexual harassment actually also includes a duty to prevent sexual harassment by third parties, but currently employees can't bring any claim in relation to third parties. That's going to change in October. And again, I think this is another big change, particularly for companies where their employees are dealing with customers regularly, for example, or other contractors, things like that, dealing with the public. From October, the company could be liable if there's any sort of third-party harassment. And that's not just sexual harassment, so any type of discriminatory harassment. So because of someone's ethnicity or nationality, disability, etc. Say if a customer comes in and is rude to them on that basis, that could potentially be harassment that the employee can bring a claim against the company about. So very difficult. And of course, there's only so much you can do to control third parties.
Yeah. And I think, yes, you are right in the sense that control over it's hard enough sometimes being able to get the workforce itself and the different contractors, suppliers, etc., who come into the workplace to comply with arrangements you have within the workplace. But if you think of sectors such as hospitality, healthcare, transport, and so many other sectors where you have third parties, that is quite hard. So you can think about, let's say, somebody coming into that setting and harassing based on any of the protected characteristics as you've outlined, whether it's ethnicity, sexual orientation, age, and all those sort of things. That is going to be challenging, but in a way, I think that's an incredibly good thing because it will make employers sit up, and hopefully it will go beyond, in some places, just lip service and posters or flyers that we put up in the workplace that we don't tolerate any blah 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 and the rest of it, and then something happens, but the reality is not much is done about those things that happen. So it's definitely a step in the right direction.
Yeah, exactly. And I guess employers just going to have to put their thinking caps on as to what they can do to prevent these things happening in the first place, in terms of who's working where at what time, and making sure people aren't left alone with customers at things like this. So it's the sort of prevention side of things, but also the how do we deal with it when things happen? Because of course, unfortunately, things will happen from time to time. And it's about how well protected your employees feel and how heard they feel, how easy it is to let the company know that it's happened, what action do they take, is it being taken seriously, Is it being kept confidential? Is the employee being cared for if something really awful happens? If you've got an employer assistance program, you're using things like that to be able to help and support them as well. So I think it's not just about preventing, because with third parties, there's only so much control you have over them, but also what you do and how you react as and when things do actually happen.
And yeah, I think you're absolutely right. And yes, what you do once an incident happens is going to make a whole lot of difference to the victim or the employee at the center of it all.
Absolutely.
And hopefully the guidance from the government will come soon enough and help with dealing with that as well. So what else do we have to?
What else? We've got flexible working, slight changes to that. Again, this is in 2027, so a little while to prepare, but it will be the same process in terms of consulting with the employee in relation to a flexible working request. You'll still be able to refuse the request on the same 8 grounds that we have now as well. The only difference is that that refusal also needs to be reasonable. So whereas at the moment it's quite easy really for employers to show that, for example, the request for the flexible working doesn't work in terms of the quality of the work that we'd be able to do for the clients, for example. And that's it. You just have to give one of those or one or more of those 8 reasons. In future, you're going to have to put a bit more thought into the reasoning behind that to show that it is reasonable. And I think here is an area where we can see there's definitely going to be lots more claims. At the moment, it's just a very straightforward statutory procedure that has to be followed to make sure that there's no claims. But having this sort of subjectivity around it and having to give a reason, I think is going to give people more of something to argue about and therefore potentially more claims. As with lots of these changes, unfortunately, it's probably going to be lots more claims coming our way.
Yeah, great. And that sort of lead nicely to my next question, really, which is what type of cases are most likely to increase with all these new aspects of employment rights?
Yeah, I think unfair dismissal is bound to be the one that goes up. Of course, it's the most common thing that happens to people is that they're dismissed. Also, a change might be that at the moment where people don't have 2 years service, but they're dismissed and can't claim unfair dismissal, you do see that they try to maybe find a different reason to bring a claim where they can bring it from day one, such as discrimination or whistleblowing commonly as well. So I think maybe we'll have less of those type of claims, which maybe have less merits to them, because it will be more easy for people to bring unfair dismissal claims as they're only going to need 6 months service. I think that's really going to be the big one.
Excellent. So it's a really it's an opportunity, isn't it, between now some of the changes coming into play this year and some coming in 2027, which is next year, which gives us a bit of space to prepare, to train, to change our policies and to do things to make sure that we are all ready for all of these, to be compliant and to take the necessary advice, etc., from HR teams, HR consultants, employment lawyers, and everyone else, just to make sure that one, our contracts, our policies, our workplace culture, training, and everything is aligned to getting us ready so that we are compliant and we can react when things don't go to plan, compared to waiting for things to go wrong before we react.
Absolutely. Yeah. We have a bit of time. It's not tomorrow, but I mean, it's crazy to think it's already March 2026 now. So 2027
Where's the year going?
come round. Exactly. It will soon come round. So I think now is the time definitely to be, as you say, looking at your policies, your procedures, and I think very importantly, managers, training the managers, making sure you have the right people in the management jobs as well, really, that will deal with employee issues before they escalate, to avoid those potential extra claims that might be happening.
Excellent. Great stuff. Is there anything else that we need to touch on in terms of the changes, or have we
I
covered
mean, I
most
think
of
we've
it
covered
on the
the most,
horizon?
yeah, the most important bits. I think the only other thing that's this year as well is about, we haven't talked about trade unions in particular.
Yeah.
I mean, that would be a subject in itself. So many changes coming in, and of course, making it easier for them to be recognised, etc. But in October this year, there'll be a duty to let workers know that they can join a trade union. So that's something to be aware of. We're still waiting for regulations that set out exactly what you need to tell them and how you need to tell them. So we don't know whether it would be enough to put it in the employment contract and whether it's just a line or two, or whether it needs to be a separate notice. So yeah, watch this space on that one. But again, that's not that far away, October. So that's one just to keep an eye out for as well.
That is a really interesting point in terms of when we're thinking again of, for most large organizations or big enterprises, there will be some sort of trade union or workforce representation, etc. But for most small to medium-sized enterprises, they wouldn't have trade union environments and or trade union representatives and stuff like that. So that is going to be a huge change for
Potentially, yeah.
employers. And it's, I know the mention of the word trade union when you're talking to, puts the fear of God in a lot of hearts of the employee, of most employers. So having a legal duty to inform your employees, even if you don't recognize trade unions in your working environment, that they could go and join a trade union and bring the unions to you, can be, I think, scary for employers, isn't it?
Absolutely. Yeah, I don't think there'd be very many employers that would say, oh, fantastic, I can't wait for this to come in. But it is, unfortunately, and they are making it much easier for trade unions. So something just to be aware of. And I think all you can do otherwise is try and have as happy a workforce as you can, so that they don't feel the need to join a trade union, and maybe have your own internal sort of committee groups for employees where there's a way for them to be heard and to put forward issues they have that management then listens to and comes back to them on. Because if they have that already internally, hopefully they're not going to feel the need to then go to a trade union.
And that is spot on, because it's easier to deal with a representative, workforce representative, who knows and understands your working environment, compared to somebody coming in who don't necessarily understand how you work, etc., how things are done within your workplace. And that can sometimes, from my experience, make things more complicated than they ought to be, isn't it?
Yeah, of course.
Excellent. So what is the big legal challenge that all this is posing for you as an employment lawyer?
All of it. It's just going to create lots more claims, and we didn't touch on this, but in terms of tribunal time limits as well, they're also looking to increase those from the usual 3 months to 6 months as well, which again gives employees more time to bring their claims. ACAS early conciliation is also extended, so the risk of claims, unfortunately, even after somebody has left, is now months and months down the line. You might think everything's okay, and then you suddenly get a claim a year after somebody's left. And just dealing with the employment tribunals generally, they're so backed up. Getting hearings is really, really difficult. I've had one recently where the hearing's been listed and it's about 3 years after the thing
Oh, wow.
happened. Yeah, in 2028. So, and this is the norm. This was only a few days hearing as well, not even a huge number of days. So yeah, dealing with the tribunal system is
That is a
definitely a
lot
big
of
challenge.
worry and a lot of sleepless nights and whatever for employers, for managers, and for
Exactly.
everyone else, because
For
not
everybody
only
involved.
is the concern about, okay, when can they bring a likely claim that's going up from 3 months to 6 months and the rest of it, but also the length of time that you have to wait until the case actually gets heard. And going up to 3 years, that is quite a lot. And the impact on the business owner or a manager or a business leader can be huge, because you are thinking about, how do I go from, okay, managing this in the background whilst I'm so worrying about growing my team, encouraging my team, meeting my targets, business objectives, business goals, growing my business profitability and everything else. So that can be quite dangerous, isn't it?
It's just very stressful, isn't it, when you're trying to do the day job and run the business, and then in the back of your mind you've got this issue that's going on for years, and the problem, of course, of it going on for so long is maybe the people that were witnesses to your defense
would have
maybe
moved
they're not
on
going to be
to
there.
other jobs, and
Exactly.
once they are no longer your employee, even getting them to come and be a witness can also be a challenge.
Yeah. So I think it's very, very poor, and obviously these changes are going to mean lots more claims, and I think the government should be doing something. Maybe they are behind the scenes, we haven't seen it yet, but you've got to hope they've got to be putting some more resource into it, because there's no justice for anybody if we're talking 3 years, maybe 4 years. Is that going to go up? Yeah, it doesn't
If
work
there are
for
more
anybody.
claims and limited resources to deal with it, then almost certainly then you are looking at that, isn't it? So yeah, thank you very much, Amanda, and thank you for your time. I appreciate you joining us. But for anyone listening to our discussion today, what top three tips would you have for them, whether it's an employer or an HR consultant or somebody within the leadership team or management listening to us?
Yeah, so I think making sure that your policies, processes are all in place in time for the various changes, and obviously accepting that some of the changes, the finer details, we don't know yet. So you've just got to keep an eye out. Obviously, we try and do webinars and things to keep everybody up to date as much as possible. So getting things in place, ready. I think the big one for me is the training of managers. Make sure that people know how to deal with employee issues and do deal with them at an early stage to prevent escalation. And I think the harassment point, particularly third-party harassment, of course, this is going to affect some employers more than others, but where they have employees dealing with the public, looking at risk assessment as soon as possible as to what they can do about that.
Great. Thank you very much, Amanda. It's been a very informative and insightful episode. And thank you, everyone, for tuning in and for listening to us. If you've listened and enjoyed this topic, please do share with your network. If you have any questions for Amanda or myself, please do get in touch with us at HR Voices at hrindependent.co.uk. Would love to hear from you and respond to any questions that you will have. And thank you, and see you again soon. Bye.
Thanks, everybody.
We hope you enjoyed this episode of HR Voices. If you have a topic you'd like us to cover or would like to be a guest, we'd love to hear from you. Connect with us on social media or email us at hrvoices@hrindependence.co.uk. Tune in next time.